What is the law relating to disclosure of the name or identity of a woman victim of rape or gang rape? Section 72 of the Bharatiya Nyaya Sanhita, which replaces Section 228 capital A of the Indian Penal Code, is clear and categorical. The law prohibits the disclosure of the name, identity, identifying features, or any material that will make known her identity. So, for instance, a photograph, her address, the name of her parents, the disclosure of any of this is clearly prohibited. This section was interpreted by the Supreme Court in Nipun Saxena versus Union of India in 2019, and the Supreme Court issued clear directions in this regard. The court held no person can print or publish in print, electronic, social media, etc., the name of the victim, or even in a remote manner disclose any facts which can lead to the victim being identified and which should make her identity known to the public at large. So, this prohibition is clear and absolute across all forms of media, not just the print media, and would apply to everyone who is posting on social media or WhatsApp forwards, etc. And it's not just a prohibition for journalists. There are two circumstances that Section 72 envisages. One, where the victim of rape or gang rape is alive, and here it says that she may allow her name to be disclosed only when she gives this permission in writing herself. We all know today, for instance, the name of Pavari Devi, who has herself allowed her name to be known to the public at large, even as she continues to fight her long battle for justice against gang rape. In the circumstance that the woman victim of rape or gang rape has deceased, the Nipun Saxena judgment held in cases where the victim is dead or of unsound mind, the name of the victim or her identity should not be disclosed, even under the authorization of the next of kin, unless circumstances justifying the disclosure of her identity exist, which shall be decided by the competent authority, which shall be the sessions judge. So, even where the next of kin or the family members or the parents authorize the name to be disclosed, the Supreme Court has held that the final determination will be made by them placing that authorization before a sessions court, and the sessions court will see whether there is good reason to make the name known. In case of a child victim of rape or gang rape, even under POCSO, there is an absolute prohibition on the disclosure of the identity of the victim. We would recall the Kathua gang rape case, where the Delhi High Court, in a suo motu matter, since the minor 8-year-old girl's name and photographs had been circulated, directed the media houses to take remedial action by pulling down her name and photographs, as well as file affidavits of apology and give rupees 10 lakh as fine. In the context of the recent rape and murder of the young woman doctor in Kolkata, the Kolkata High Court, in an order of 16th August 2024, has categorically directed that the name, the photograph, any identifying feature of the rape victim is not to be circulated. The Honorable Supreme Court, hearing a suo motu matter on 20th August, have again said the Chief Justice of India has reiterated the Nipun Saxena direction and said the name, identity, photograph of the woman doctor, the victim of rape and murder, is not to be circulated. Section 72 of the Bharatiya Nyaya Sanhita makes this a penal offense, which entails an imprisonment which may extend to 2 years, and a fine. The court in Nipun Saxena held that while there does not seem to be any justification in making her identity known, the disclosure of the identity can lead to hostile discrimination, stigmatization, etc., and therefore has upheld the bar of disclosure of name, identity, or any identifying feature in the public domain of the victim of rape or gang rape. There is, however, no bar, no prohibition in publication of court orders relating to cases of rape or gang rape, as well as judgments of the same.